What's up, STS Nation, and welcome to another episode of Surviving the Survivor, the podcast that promises to bring you the very best guests in all of true crime, and today is certainly no exception. We are diving back into the Lori Vallow Daybell story. It is day 2 of her long-awaited murder trial inside a Boise, Idaho courtroom. It is a trial of the so-called Doomsday Mom, the wildly twisted story of a seemingly loving mother, a devout member of the Church of Jesus Christ of Latter-day Saints, who becomes involved in the deaths of as many as 5 people, including her very own children. Best guest today, returning to the show when we are grateful for it, Dave Leroy is a trial lawyer with 5 decades of experience in preventing and solving problems for his clients. He has served as, listen to this, Ada County prosecuting attorney, where this is all going down, and Idaho Attorney General, the top law enforcement officer in all of the great state of Idaho. And he was also Lieutenant Governor of Idaho and the United States Nuclear Waste Negotiator. Currently, he specializes in criminal defense cases. And then we've got Jean Fisher, recently retired, although she's still working a bit, after nearly 33 years of service at the Ada County Prosecutor's Office as the Special Crimes Unit Chief. During law school, Jean interned at the prosecutor's office before being hired directly out of law school in 1989, not to date her, and by 1997, she became the supervisor of the sexual assault unit and has focused on those cases ever since. Probably no one knows the Ada County Courthouse better than Jean Fisher. And then, of course, Tara Malik is returning as well. She has joined us, as did Dave, on the Idaho 4 case. Tara is an Idaho licensed attorney practicing in state and federal court in business and commercial litigation and has experience in both civil and criminal law. So, Dave, I know your time is a little limited. So right off to you, out of the gates, 5 people close to this couple, to Lori Vallow and Chad Daybell, have wound up dead. They're each now being charged with first-degree murder, conspiracy and grand theft in connections with the deaths of JJ and Ty Lee, and conspiracy to commit first-degree murder and the death of Tammy Daybell. And they're also charged with financial crimes. This is not unlike, in some ways, the Alec Murdaugh trial that we were covering gavel to gavel, as we are with this. What is your 360 bird's eye view of this case, Dave? And the state of Idaho is getting hit hard, obviously, with a quadruple homicide, and now home to this infamous trial as well.
Well, these are dreadful facts as well as deadly facts, and it's really sad that someone could not have interceded in Arizona, or these children that's a missing status could not have been detected earlier, and somehow some portion of this dreadful pile of deadly facts could not have been interceded at an earlier level. This is a good test for the state of Idaho to find out whether, and I believe we can, under these trying, internationally noted, highly publicized circumstances, provide a fair trial to the defendant. Ms. Vallow, now in the jury selection process, headed toward opening arguments and headed toward the presentation of evidence here quite swiftly. I think Idaho will rise to the occasion. The judge, Judge Boyce from Eastern Idaho, sitting here in Boise, has shown good control of his courtroom, and I would expect that this will be a trial that is properly conducted and hopefully reaches an appropriate verdict, even though the facts here, as I say, have been accumulating over far too long a period and are far too sad for all the people involved, and particularly those who are victims or who have lost victims.
And Gene, I hate to put you on the spot since you're joining us for the very first time, and I don't know the answer to this question, and I should, but Tim is asking how many jurors selected today. Do you happen to know?
No, I was looking earlier. I think that they had selected 5 more the last I saw, so they were up to 22, and they need to get to 42 before they will release the jury pool.
And that 5 number is the same amount that I saw as well. We've got Kitty saying hello to STS. We've got Lynn, aloha from Hawaii. Carrie G checking in. And my favorite name, everybody, as everyone knows, Shaquille Oatmeal joining us today as well. Gene, same question. I mean, Dave's got some of the very vaunted titles in the state of Idaho, but you've been around not quite as long, but you've got a history there. What is your take on this case? Hang on, so we just have to unmute you. I'm sorry. I think see if you, there you go. I'm sorry.
My take is a lot like Dave's. I mean, it's an extraordinarily sad case. I think that one of the things that we get caught up in sometimes is that because the children are involved, but we also have the murder as well of Tammy Daybell, and she kind of gets, we don't talk about as much about her. We have 3 murders here in Idaho, and then of course there's other things going on in other jurisdictions, and certainly this didn't just come about in a short period of time. I think that Dave is right in that there were a lot of things going on in Lori Vallow Daybell's life that unfortunately people weren't able to intervene sooner. The talk of mental illness and just some of where she was going with her religious fanaticism, things that she was talking about certainly should have alarmed a lot of people. But on the other hand, they did an awful lot, it sounds like, to hide the children. They had them removed from school, or so that people who could have been more supportive were not there to see the kids and check in as often as well. So it's extraordinarily sad. I think it's going to be a very difficult case for the jury to hear the evidence in this case. And there will be some things that just won't be answered for them. It sounds like that they're still going to have to arrive at a decision with the circumstantial nature of the case.
And shout out to Jimmy C, who's a friend of the show. He says, glad to see you back, and the gang. And then, of course, Papa Bear, hello from Moscow, Idaho. Obviously, a place that's near and dear to all our hearts, and now we know all too well. Dave, I was speaking to Jessica Bublitz, who's a defense attorney out of Boise, and Tara, I did not forget about you. I'm coming to you, but I know Dave has got to run out. But I said that Idaho is being hit hard, and as a good defense attorney would, she jumped back and said we're being victimized from the outside. Do you feel that way? Because Lori Vallow came from Arizona, Brian Koberger from out of state, and Idaho is getting the short end of the stick here with these 2 infamous cases going on almost simultaneously.
Well, I guess if you must find some solace in these 2 cases, perhaps that's a place to park. But in the modern world, with boundaries called state borders that sometimes mean a lot for some purposes and not much for others, we've got a lot of influx of new people in Idaho. We've got narrow geographic spires like our panhandle, where the Washington border is just 6 miles away from the University of Idaho. So I don't take much solace in the fact that we've got people coming in here, because we expect everyone in this state to comply with the requirements of civic good judgment and the law. Both of the 2 women who were on with me today and on with us today have been prosecutors and have done a good job of enforcing that law fully and fairly. We don't discern between where someone started out. We just expect everybody who's within our borders to comply with the law. And when challenged, as we are in these 2 terrible cases, we expect to proceed logically, appropriately, constitutionally, to enforce the penalties that come with breaking the law. I'm a defense lawyer who's represented clients against both of these women, and I can assure you they're up to the task, regardless of where you start out in life, inside Idaho or outside.
Well said. Tara, you are muted, but I'd like to get your take. This is obviously an uphill battle for the defense, and I'm not an attorney, but what would your strategy be in trying to defend Lori, which I know is a huge question to ask, but to me, the obvious answer is you blame her brother, Alex Cox, who's deceased. Is that a smart strategy, or how would you play it?
Well, I think it's a battle for the prosecution. I mean, at first, the burden of proof is on the state to prove their case beyond a reasonable doubt. And that's not to say that the defense doesn't have a burden as well. And certainly those jurors sitting there are going to want answers. They are going to want to have explanations. As I think Jean mentioned previously, there is a pretty large component of this case that's circumstantial. And so one of the best strategies that I think the defense can capitalize on is really looking at those circumstantial pieces of evidence and providing alternate explanations for what's being presented to them. One of the other biggest burdens for a prosecutor is not only describing and entering in the facts as they occurred in any sort of circumstance, but it's also providing an explanation as to why. Now, they're not required to do that. That's not one of the elements of any one of these crimes, but you're going to have to convince these people on the jury, why would someone go to these lengths? It has to be a plausible recitation or a plausible story here. And so for the defense, if I was on the defense side, which is going to be a stretch for me because I was a prosecutor, state and federal prosecutor, but if I were on the defense side, I'd be listening awfully closely to the evidence as it comes in on that circumstantial portions of this case and really leaning in and providing explanations where perhaps the state may not have one. And
Jean, to you, and by the way, Eileen, thanks so much. Welcome back, Joel. Sending sympathies about my father. I appreciate that so much. Hi from Portland, Oregon. We've got a lot of ground covered. Papa Bear is always looking out for me. She says, thumbs up for Joel and this great channel. Thank you so much. I appreciate that. But Jean, you know the Ada County Courthouse better than anyone else and the process that's being undertaken right now. Can you kind of just walk us through this jury selection process? From what I understand, potential jurors filled out this questionnaire last week, and those who kind of passed the smell test were brought in this week and are now being questioned in the voir dire process. Can you just let the audience know sort of what's happening hour by hour as they're choosing this jury right now? Oh, you're muted. You just have to unmute yourself.
Well, right now, the jury is being brought in small panels in order to protect essentially the large jury pool from hearing something because of all the pretrial publicity. So they're being brought in small panels at a time and being questioned about primarily, it sounds like, pretrial publicity and how much they know or don't know about the case and whether the time commitment, if they can be fair to the time commitment as well. And so they're being brought in panels of 10 to 12 people at a time, and they're mostly being questioned on those issues at the moment. There are definitely times though where, because it's pre-publicity, that jurors do know quite a bit, and so those jurors are now sounds like they're being questioned individually to discern how much they do or don't know. Just because somebody knows a little bit about the case doesn't mean that they can't be fair and impartial. And the judge wants to make sure, as do both parties, that what they do or don't know aligns with their ability to be fair and impartial. And so that's what they're doing right now. Once they get to that number of 42, then the attorneys will really take over and be able to really work the jury and voir dire them about all the other issues and themes of the case that they need to work through. As Tara mentioned, there are questions here that they may not be able to answer. For instance, as we've read, they may not know how one of the victims died. But you can work through. You can work through all of that and through a lot of this. I think that the circumstantial nature of the case, the way in which the children were missing for as long as they were, the lead up and the build up to all of this, I think that the state can work through those issues, but they have a lot to work through in the voir dire process. They've got a lot of themes that they're going to have to hit, a lot of conversation about religion, about more conversation about children, about people's involvement, and because they've charged conspiracy, the state has a lot of other ways in which to go about proving this case, and those are all different themes that they're going to have to weed through in order to get their jury ultimately of 18.
And again, just Alec Murdaugh is a case that we covered very closely. The judge in that case, Clifton Newman, he ran a very tight ship, and that jury was chosen, I think, in 3 days. You know this better than anyone else. If you had a guesstimate, how long before a jury is actually seated and this trial begins?
I think they had hoped that they were going to get a little bit more today. Now, they could have here. The judge yesterday had them going until about 6 o'clock at night, and then had everybody back this morning bright and early. And so today's just the second day. So surely they can get a jury of 42 by the end of the week, I would think. But they brought in a number of small panels today, and large amounts of them were all dismissed relatively quickly. So it's really kind of hard to know. But I do think that this judge is doing this as carefully as he can, so that it avoids contaminating the rest of the jury, and just making sure that they get it right.
And Natalie Cassidy writes, Joel, how is mom? It's going to be a long struggle for her. However, I'm happy to report she started cursing today, so she's somewhat back to normal. And I was happy to see that. Hello from Colorado here. Dave, back to you. And Gene touched on this. I mean, the remains were found back in 2019, I believe, and they still have not been returned to the family, to the grandparents. How odd is this? Have you dealt with this before in your long career? And what's it like, or what do you imagine it's like for the victims, the families in this case?
Well, of course, that's a dreadful result for the victims' families, but it's important to literally, quote, preserve the evidence of all types during a trial proceeding, probably during some portion of the appellate proceeding, so that if a later question comes up about whether something was done correctly or incorrectly, even during the course of trial, perhaps a validation can be had one way or the other. So while it is almost inhumane not to have treated these remains with more dignity more swiftly, to achieve an appropriate justice for those victims, sometimes it's necessary to follow an incomprehensible procedure, but an appropriate procedure. I think that's what's happening here.
Tara, back to you. You hear this expression all the time, a slam dunk case, and people presume that, in a court of public opinion, many people, because I get the emails, believe that she did this, believe that Chad Daybell did this. But is there such a thing, in your opinion, as a slam dunk case, which is a phrase we hear all the time?
There really isn't. I've had a number of trials, jury trials, bench trials, and I can tell you I've had cases that looked like they were just slam dunk cases, and I took them to trial and a jury came back and disagreed. And I've had cases that were more of a stretch and it was more circumstantially based, and I've had the reverse occur. So there's really no such thing as a slam dunk case. And I think something almost magical happens when people are seated in that jury box and they become jurors for a case. They take that job incredibly seriously. And they really focus on the elements that the state and the defense, if there's some sort of affirmative defense in different types of cases, have to prove. And so I would expect that these jurors that are eventually seated are going to be no different. They're going to take their jobs very seriously. While the death penalty is, for Lori anyways, is not on the table anymore, we're talking about taking away someone's freedom for the rest of their life. And a transformation does occur for those jurors once they get seated in there. And I think we are going to see individuals that will be paying very close attention and really making sure that the state meets their burden, their high burden here in this case.
And Papa Bear got me. I was getting to this, but I've realized that Dave is going to be leaving us sooner than we'd like. So let's get to Papa Bear's question here from Moscow, Idaho. Interested in the guest perspectives on cameras not being allowed in the courtroom and being charged for each day's audio recordings, and charged quite a bit. Gigi McKelvey of Pretty Lies and Alibis did the math, and for a 10-week trial, I think it would come out to $6,000 at the rate that they're charging. As an Idahoan, I think it's a travesty, especially to the grandparents who are Kay and Larry Woodcock. Dave, back to you on this. What about this, what can be argued as a lack of transparency? Judge Boyce not allowing cameras in the courtroom, whereas sometimes we do see them. In the case of the Trump indictment today, no cameras were allowed. But what about as it pertains to this particular case?
Well, once upon a time, just as we have in this trial, we had artists in the courtroom who were drawing pictures of witnesses of the overall situation, of visage of the judge looking down from the bench. And I've even got some of those pictures where I had brown hair. So it's not entirely without some possibility of the human beings who are interested, both inside and outside the courtroom, having some sense of participation. I don't know anything about the rate at which they're charging for audio recordings, but I do know we have members of the citizenry in the actual courtroom. We have a sub-broadcast to an overflow courtroom. We are making arrangements to do the audio, and the images from the courtroom will be available to illustrate video stories. So that's probably the next best thing. And it shows me once again that this judge is not going to allow this to denigrate into any kind of circus inside the courtroom. So a pool camera now these days can be relatively unobtrusive. But in the good old days, when images were drawn by artists, cameras were big, they had Klieg lights, and it really was a circus. So I commend the judge for making sure that this is a fair trial without a circus atmosphere. I'm sorry it can't be more open, but the alternative arrangements that are made are not inconsistent with the history of criminal justice in this state or around the country.
And Gene, I would love to get your take on that. And what is the protocol these days? Are there typically are cameras typically allowed in recent trials? Is this a diversion from that? And your thoughts?
It really is case by case, and it's up to the judge and each presiding matter to make the decision whether or not to allow courtrooms in the camera. I didn't think that Dave and I would have so much to agree about all the time, but but I agree. I mean, this case already has so much. There's just so many factors that are involved in this. It has had so much publicity. It's been on Dateline. There's been so much publicity that having the cameras in the courtroom, I think, does add concern about more publicity. As Tara mentioned, there is something magical that happens once the jury gets seated, that they really do take their job professionally and thoughtfully, and as citizens, it's the highest duty, and they will be reminded of that at every break, not to listen to the news, not to pay attention to cameras outside, not to read the newspapers. I mean, they will be reminded of it over and over and over again. But there is something to be said about cases sometimes where the media is allowed in the courtroom and the trial gets away from people, and you start playing, and it starts playing on itself, and it looks more of a circus. And in the end here, this is really serious stuff. I mean, we have three victims who have been murdered, I believe who have been murdered. I think we have 3 homicides. We have someone who has been charged with these crimes. We want a fair trial just once. We don't want to do it a second time. And there are enough issues in this case that we don't need the media involvement necessarily in the courtroom to get things on its head. So I think we're doing as much as we possibly can to keep the public informed of what's going on, but not having the cameras in the courtroom.
That's an interesting take, both with a long history in the legal profession, both in favor of no cameras, whereas STS Nation is a bit outraged that there are no cameras. So the court of public opinion differs from people who are in the legal profession, and this is a perfect example. So, Gene, I'm 53. I'm not sure what I want to be when I grow up. How did you know at a law school that you wanted to intern at the prosecutor's office and then spend an entire career there? A Larry Bird jersey, 33 years. How do you do that? Why?
It even goes back further than that. My sister was a secretary in the prosecutor's office when I was in high school. And the office was just a few blocks away. And I used to walk over there during my high school. I was the editor of the Boise Highlights. And I used to walk over and rummage around and look for stories to talk about First Amendment and Fourth Amendment and things like that. And so I kind of grew up knowing that office. And, in the end, interning there, taking up these kinds of cases where I believe that prosecutors are the true public defenders in the world, that we are the true public defenders against crime and for civility. And it's just something that spoke to me. I didn't know that I would go into the type of victim cases that I did, but those are cases that I was really compelled to work on. And I was really fortunate. I mean, I had one boss, the elected prosecutor in Ada County for 25 years. And then after that, a second elected who, the stability of that kind of office is amazing. And so I was really lucky.
Dave, is it fair to say that Jean is a bit of a legend in Ada County? And what was she like in that courtroom, Dave?
Well, I'm always worried about calling somebody a legend or an icon because most of the legends and icons I know are dead. But Jean deserves the title of a very significant, long-standing figure who has made a difference in our community. No question about that. She was tough to try a case against. She was tougher to negotiate against. The world is a better place for Jean Fisher having worn the prosecutor's robe.
See, it's nice to hear that while you're still alive, Gene. So there you go.
Yes, it is. Dave and I tried a few cases against each other, and well, I'd like to
and you
that.
won. You won.
Yes, I did.
No
well,
comment.
Was that one time.
No comment from Dave. Somewhere over there writes, so it is reported, Tara, this one's for you, that Lori is laughing while chatting with her attorneys. And I've seen that on these live tweet streams. The potential jurors are witnessing this behavior, right? Are they watching her, these potential jurors, as she's laughing? And what would you instruct your defendant to be doing, Tara?
Absolutely, they're watching her. I think the case starts really when those potential jurors walk into that courtroom. They are going to be looking at the defendant. They're going to start making and observations, and they're going to carry some of those observations through to the end of trial. And so if it were me, if it were my client, I would be advising them to, have a sense of decorum, the sense of decorum that this type of case really demands, given the serious nature of it, given the tragedies that have occurred. I would not be advising, laughing and giggling and smiling or whatever else, that kind of lighthearted behavior really doesn't have a place. There are circumstances where, for example, in the Alex Murdaugh trial, there are points of levity in the case, and naturally everyone will laugh. There might be a joke to break the ice or the tense moment. Certainly those are different situations and circumstances, but just to sit there during the preliminary proceedings here, and laugh and smile is definitely not the impression you want to start making.
KCL, who's a friend of the show and following this very closely, puts this on the record for all of us. 3 jurors left to go through voir dire, 27 out of 42 selected so far. Coming up big with the numbers. We've got the Czech Republic in the house here, Ziza. So we've got a global audience. And then Bonnie Hitchcock writes, first time on a live. Give a shout out to the South, Georgia, USA. We covered the case out of Cotton County in South Carolina with Alec Murdaugh. So we've got a lot of Southern friends here. And then hello from the great Northwest and in Seattle. Dave, to you, kind of the same question I asked Tara. Is there such a thing as a slam dunk case? And if you are defending Lori Vallow in this trial, what sort of strategy do you think you would devise to try to get justice for your client?
Well, I agree with Tara. There are no slam dunk cases. The strongest cases I ever had as a prosecutor, I feared because I was uncertain as to what might fall apart next or first. So it's difficult when you have the burden of proving every element of a crime beyond a reasonable doubt to make sure that all the pieces fit, that all the witnesses report on time, that all the evidence gets in. There are no slam dunk cases in a process as complicated as criminal justice. The defense here, I think, needs to sit back and be as strategic as they can. They will have had hundreds, thousands of pages of discovery, literally. We know that they got 5,000 pages at the last possible minute, which I think was probably a factor on the judge taking the death penalty off the table. We also know that they probably have retained some of their own scientific evidence experts on some of these aspects of triangulation of cell phone or cause of death. The problem I think that defense has most in this particular case is that 5 or 6 months of very eloquent silence wherein the mother of these children was not reporting or cooperating with regard to their absence from the world. That speaks pretty significant volumes about her somehow being complicit or confused or under the influence of an abnormal religious belief about where these children were and what she should have been doing. So there will be a strategy that the defense has. Whether they will call her as a witness is up in the air, and a decision that will be hers and hers alone, but at the last minute in full consultation with her defense team. So I think we'll just have to sit back and be witnesses to whatever it is that they think they can pick apart by virtue of cross-examination or the contesting of particular pieces of evidence, see whether there is some opening for the defendant herself to testify consistent with whatever they think a successful defense might be. It's up in the air, and we won't really know until all of the pieces begin to fit together.
And Dave, since I know you have to run in a few, were you surprised that Judge Boyce took the death penalty off the table in this case?
Well, it was a relatively unprecedented maneuver, in my opinion. And I would be very interested, and I will have to go, but I would be very interested in having you pursue with the other two very experienced prosecutors in your panel why they think this may have happened. At one time, when I was a graduate law student at New York University, I wrote a novel law review article on the motion in limine, a technique for the pretrial exclusion of evidence. And you'll recall that about the time that the defense received 5,000 pieces of new evidence and 30 hours worth of testimony from the prosecution in a last-minute discovery dump, a literally last-minute discovery dump, that they filed a motion in limine to preclude the introduction of that evidence in the trial. I think the judge was faced with a very difficult choice to give the defense or order the defense to take more time and study that against Lori's wishes for a speedy trial, or in the alternative, to preclude some or all of that evidence from potentially coming in, even if it was earlier disclosed because it was redisclosed in this new dollop, or do something novel like take the death penalty off the table. So I think he awarded the defense a partial victory by taking the defense position halfway, that the defense should not have to face a death penalty scrutiny in this case, making every evidentiary objection a Supreme Court argument, speeding up the trial and focusing it more properly on the issues of proof of who did what to whom, rather than that undercoating, that underlying issue of, is this something for which somebody should be put to death? I think it was a halfway compromise with a recognition to the defense that they kind of caught the prosecution in an inappropriate move at the last minute. That's my opinion. And I'll have to drop off, and I'm eager to hear, as I know your listeners are, what the ladies would have to say on that.
And that is not just any guest. Thank you, Dave. That is Dave Leroy, the former lieutenant governor, the former attorney general, the former prosecuting attorney for Ada County. Dave, we thank you for joining us and hope you'll come back as this trial plays out.
Thank you.
And we'll get back to the death penalty issue. But, Gene, this is an interesting question from Amy in Boston. What is the chance of these potential jurors knowing this case like we do, wanting to get on to convict her? Because it is a high-profile case. Books can be written. You can appear on TV shows. How concerned were you in a high-profile case of a situation like this?
Well, I mean, that's why I think that's why this judge is being so careful with with this jury panel. 1,800 jurors were called in. They had a 20-page questionnaire. And now they're being brought in relatively small pools to try and ferret out who knows what about the case. And, jurors are sworn in, and we ask them to tell the truth about their knowledge, and in this instance specifically about pretrial publicity, and how much they know or don't know. And while they can certainly hide that, we hope that they don't. We're looking to make sure that they aren't. We really are interested in a fair and impartial jury. A lot of things can go wrong when jurors aren't truthful in this matter. They get back into the jury room and somebody slips, or somebody starts talking about having a conversation as they familiarity, and the trial goes on, and you get to know your jurors, and they tell somebody the things that they saw, and it pollutes the whole panel, and then you have to start over again. I mean, it's very serious business, and so while it's hard to believe that some folks are coming in saying that they've never heard of the case, which has been reported. More likely what we've heard is people have walked in and said, well, they knew a little bit about the case. And then, of course, there are those who straight up, so they watch state line, they know a lot about the case, what they believe that they've already seen and heard. So, we really need jurors to be fair and impartial, because it does no side either favor here. And if jurors slip this up and then we find out in the middle of this that somebody wasn't fair and they've been watching all along, we got to start everything all over again. And that truly is a travesty for everybody.
And a shout out to Mabel Quintanilla, friend of the show. She is ready to watch and learn. Tara, over here, this comment, I have problems believing that Lori does not know what is happening with her and believing that she won't be held responsible for her reactions. Do you have any reaction to this comment?
I think the comment is, I think it's really goes to her capacity. So her competency and some of the competency issues that were at issue and in play a little bit earlier on in the case. I think, she was deemed to be not competent to stand trial early on. That changed. She spent, I think, 90 days away and getting treatment. She's now been adjudged or decreed to be competent to stand trial. I think She's certainly in a place where she knows what's going on, and that's based on the opinion of medical professionals. So I would hope that she understands the seriousness of these proceedings and what's going on around her.
And were you surprised with the issue of the death penalty being taken off the table when you found that out?
I was surprised. That's not a usual thing that you see when there is late disclosure of discovery, and discovery is a very important period of time between the attorneys in a case where they're exchanging information. So we don't do trial by surprise. We exchange the information prior to trial. Everyone knows what everybody kind of has, the cards on the table, and then you proceed forward to trial. Having a sanction, a discovery sanction, include taking the death penalty off the table is unusual, and I was surprised to see it. I read through the decision and understand why it was made, but I would say that this is not typical.
Carrie writes, hello from Rexburg, Idaho, which is where the remains were found. Following Nate Eaton's updates from East Idaho News. Shout out to Nate Eaton, who I don't know, but provides great information. She says she plans on being in the Rexburg courthouse once the trial actually begins. Wanted to get that comment in there. Gerald writes here, Gene, I'm hearing that the prosecutor is really questioning people with children. That's probably a smart move for the state to try to get people, right, with kids.
Yeah, I mean, it's both. You know, they need to work with the jurors that they have, and you know, most of them probably do have children, and that's obviously a huge part of this case is the victimization of those two children, not only with their ultimate death, but even leading up to that, and what were they exposed to that the jurors will find out about leading up to their death, and what was going on in that house prior to when they died. So I'm sure that they're asking jurors about would they be able to be fair and impartial, knowing that there are children involved in the deaths of these children and that their mother was involved in that. In some capacity. And remember, she's charged with both the murder of those children and then the conspiracy to murder those children. And so, you know, the state has a lot more leeway in the way that it's been charged as far as evidence that it's able to bring in about her knowledge with actually complicitly involved in their murder or involved in the act itself. So yeah, I mean, it's gruesome. I mean, you know, the way the children were found on Chad Daybell's property in garbage bags, delimbed and burned, and I mean, just it's awful. And we want to make sure that people can work with that, which is really tough. You know, I mean, these folks are just coming in from their regular lives, right? And we call jurors in. Oftentimes, you know, this would happen in some of my worst child abuse cases. We call folks in and they don't know what they're coming in for, although in this case, obviously they do, but they don't know the context of all the evidence that they're going to hear. And you start to read the indictment, the judge reads the indictment to them, and you can start to see the look of panic on some, horror on others' faces, and people's own experiences as adults, and reflecting back on their own childhood. And I often wondered how many victims we had just in the jury panel, and you don't get to offer them counseling when they walk out the door. You know, some of these jurors could really, really be affected by what they're going to hear and the decisions that they're going to have to make. And, you know, we know that can be really, really tough on folks. And we're asking them for a heavy lift in this constitutional duty that we have. And it's a tough one.
And they are asking if they can handle looking at gruesome autopsy photos and things of that nature. Venus Gal here writes, Gene, this is just giving an idea of how STS Nation is coming at this. The judge is careful and takes time, but that and other things resulted in the case being severed and Lori's death penalty being removed. Not impressed. Followed again by KCL, who's following this very closely. The judge doesn't seem to be letting any jurors pass through if they know about the case. It is another indicator of his secretiveness and suspicions of potential jurors, evidence of his lack of trust, in my opinion. Curious your thoughts on this comment. And also, do you know Judge Boyce?
I don't know Judge Boyce, and I've never appeared in front of him or practiced in front of him at all. And I just don't think that that's an accurate statement. I don't think that there's a secretiveness or a suspiciousness of and his nature. I mean, I truly believe that he's looking for fair and impartial jurors. This has had a tremendous amount of publicity. There's been books, there's been datelines, we know how much has been out there. And so I think that it's important to make sure that, the jurors that we have can be fair and impartial. I don't know if everyone is being kicked off, if they've even heard about the case. I didn't think that was the situation. That's not been my experience in some of my bigger cases in Ada County. We don't ask jurors to leave their common sense at the door. We don't ask them, we expect that, jurors have been paying attention otherwise, but we need to make sure that they are prepared in this instance to give this their fairest mindset. And I can't really emphasize that enough. We only want to try this case once. It's been a long time coming, right? I mean, this case has gone on for a long time, and it's time to get this thing off the ground and get it moving.
Misdemeanor writes, during voir dire, can the lawyers strike people for being a certain religion? Tara, can they?
No. The answer is no. You cannot. It's a good question. So I don't mean to make light of it. It is a really good question, but no, you can't do that. The jury selection process is really a deselection process. So what you're going in is with a group of people, potential jurors, and then the lawyers are going in and deselecting people that they think can't operate in a fair or impartial manner. They can't weigh the evidence. And you've asked, some of those questions about children, for instance. Religion is not a basis where you can strike a juror. If someone comes in and says, for instance, that they believe, that they can't ever sit in judgment of anybody else, they will not follow the judge's instructions as to the law, that's a different situation. In that situation, the judge would excuse upon motion from one or the other side that juror for cause. Or a peremptory can be used later on, but you can't just straight up get rid of somebody because of their religious beliefs.
And that's why we have our lawyerly guests on to answer these questions. Leanne writes, David Leroy, always represent Idaho. Appreciate him as lieutenant governor. I've had the pleasure of meeting Mr. Leroy, a true gentleman, and we will let him know that you said that. A gentleman who Gene Fisher beat in the courtroom, for the record. Sky Ricky writes, for the Murdaugh case, no one in the jury was allowed to take notes throughout the trial. And what do you think about that, Gene? We're going to get to you in a second on this. It forces the jury to pay more attention, in my opinion. What is the deal with jurors and their notes?
I've never had a situation where jurors were not allowed to take notes in the courtroom. What they are instructed is that while they can take notes, no one can be a scribe, or no one can be assigned to take notes for the rest of the jury. And that ultimately, if there is a description or a discrepancy between their notes and what they remember, they're rely on what they remember. But I've never had a case where jurors weren't allowed to actually write notes. They're protected if they do, so that nobody else is supposed to be able to see them. The courtroom is sealed. They're not allowed to take them home with them. And like I said, they're not allowed to use them as a substitute for what they actually heard in the courtroom, or to have somebody assigned to be like secretary, if you will, or a scribe. So that's all I've ever heard of that before. I've never heard of not being able to take a note.
And Tara, to you, Suzanne writes, why would Chad Daybell's lawyer be allowed to be in the courtroom overflow where media are? Has it been decided if the grandparents are allowed to be in the courtroom yet? I have not heard of a decision on that. We're talking about Kay and Larry Woodcock. I don't know if Tara has, but what about the fact that the other defendant, now that the cases have been severed, that his defense attorney was in fact there today? Tara, is that normal?
Well, I think when the cases are severed like this, there's still some commonality of facts. And so I guess I'm not surprised that he would be allowed into the overflow room. As to the question of the grandparents being allowed in the courtroom, I checked right before we kind of hopped on here, and I didn't see that the court had made a decision as of about an hour ago. I think it was predicted that a decision on that would be given today. Certainly a extremely difficult call, given the fact that the grandparents are both witnesses and victims in a way in this case as well.
And Sue L. writes, and Gene, this is in response to what you and Dave had to say, totally disagree with these opinions for a closed court. Scrutiny and transparency is a vital component of our justice system. We all know what tends to happen without it. I just want to give you a chance to respond because, as I said earlier, STS Nation is up in arms, and this is the court of public opinion, that there are no cameras. So you are a fierce litigator. What's your response to this?
Well, while there aren't cameras in the courtroom, there are cameras that are being allowed for the press to see. There is an overflow room. The press is able to see what's going on in the courtroom, as is a certain amount of participants who are, essentially lottery to be able to sit in the courtroom. Plus, they'll be able to see, I think they're going to have a camera in Rexburg as it goes on live stream as well. I had heard that. It's not being played for the general community. But the press is going to be able to watch this as it takes place. It's just not going to be in the community. And so, the press is going to be able to report on it. First Amendment rights, they're going to be able to see what's happening and talk about it. I know that people want cameras in the courtroom and think that that's the way it should be all the time. But as Dave said, there was a time when, we didn't have that. And the case went forward, and really this is for the jurors to decide this case. This is not a case for the entire general community to decide the case. We have a system of laws. We're going to pick a jury, and that jury is going to make the decision. And we all hope that, as a prosecutor, we all hope they come to the right decision. But we don't get to try this as a community, if you will. And so I am certain that the press will get access. I do think it's. I heard about the cost, and I'm really surprised at how much they are charging in order to get the transcripts. I heard that from one of our media partners here in Boise. And they were really complaining about the cost and how they were going to be pooling their resources for some of this. I've never had that instance before, but I have full faith in the jury system itself, and I am certain that this jury will be better off, quite frankly, not having cameras in their faces, and they will participate and listen carefully to what's being presented to them, and they will make a decision. We've also seen where the press being allowed in the courtroom has had really negative effects, where they play up to the jury. And the jury starts to pay attention to what the camera is doing, and instead of paying attention to what is actually happening in front of them. So I've seen it go both ways for sure.
And not to beat a dead horse, but I'll take a couple more questions on this and move on from there. But HMS 19591 writes, It seems to me this judge, and by the way, there is a sketch artist, but it's not a courtroom sketch artist. That sketch artist has been hired by different media outlets. They're pooling their money together, and that's sketch artist is sitting in one of the overflow rooms watching basically the Zoom monitors and sketching from that. And apparently it's hard to tell detail because the cameras are in a wide shot. So a little factoid there. But HMS writes, it seems to me this judge is siding with the defense more. No cameras in a very high-profile case makes it seem like they have something to hide from the public, Tara, followed by this comment from Susan Moore. The judge apparently doesn't agree with the Supreme Court regarding cameras in the courtroom and the First Amendment. He must be very old school. Do you agree with Gene and Dave that it is not necessarily a bad thing that there are no cameras?
I think there are pros and cons to having a camera in the courtroom. It was almost 30 years ago now that we had the O.J. Simpson trial, and Judge Ito had ruled that they could have one camera in the courtroom. And, I remember that in that case, both the defense attorney, I think it was Robert Shapiro, and then Mark Shaver came out, and they both wanted the cameras in the courtroom for different reasons. Robert Shapiro had come out and said that, that he wanted the public to see that there was going to be an acquittal and that the case was tried fully and fairly. And I believe the prosecution had said very similar things. And so fast forward, almost 28 years, 30 years later, to now, and we're facing a very different situation with both the prosecution and the defense attorneys agreeing that cameras shouldn't be in the courtroom or requesting that cameras not be in the courtroom. Any case like this is going to be high pressure for both sides. There's a lot at stake. It's someone's livelihood. Certainly, as I said before, the state has a high burden of proof. The defense has their job cut out for them as well. Media and media scrutiny and cameras can certainly add to that. The court was really taking into consideration, the judge was taking into consideration there's right to being tried fairly and fully, and it's a constitutional right. But on the flip side of that, we have allowed cameras access into our courtrooms. We've allowed the public to view cases, even high profile cases before, like the O.J. Simpson trial. I think there were some lessons there. I think that this fear of it having sound bites or playing up to the camera and it turning into kind of a circus is a really real fear. I think that occurred in certain instances at certain parts of the O.J. Simpson trial, and I don't know how much the judge was considering that. Certainly nothing in the opinion to indicate that he went down that road, but just something else to consider here. As a member of the public, I would have liked to see what was going on in the trial, but I understand that the court has discretion under the court rules.
Janet B. writes, hi, everyone from southeastern Idaho, where I understand, well, I don't know if it's snowing in southeastern Idaho, but it's snowing in a lot of the rest of Idaho and in Utah. And I don't want to rub it in, but I'm in Miami Beach, where it's a little hot here today, almost 88 degrees. But I'm thinking of you guys. Sorry about that. Suzanne writes, this is a relatively new judge, and I don't think he realizes that making this so secretive only serves to cause increased speculation, in my opinion. So that debate will continue. Gene, I thought this was interesting. It was revealed today in the courtroom. Obviously, people knew this ahead of time, but Idaho law prohibits employers from penalizing employees for serving jury duty, but companies do not have to pay you for jury service. Many employees take accrued pay leave when they serve on a jury. So some people today said it was going to be financial hardship because they weren't necessarily going to get paid. And then it was also revealed in court today that the state of Idaho pays jurors $10 per full day of jury served, or $5 for each half day or portions of a day served. That's definitely not the fee that a criminal defense attorney makes. Does that need to change? Because that, I think, in your opinion, is one of the most important jobs there is.
Yeah, it's pretty antiquated. I think that's a raise. Last time I did a trial, it was $8 a day, and now they're up to 10. It is a civic duty. It's part of our judicial system for jurors. We don't have professional jurors like they do in other places in the world that actually sit for long periods of time and hear many cases. And our laws here in Idaho and employment laws, I don't know that they're that different. I don't know if they compare to how they compare to other states as far as who gets paid for what for loss of jury service and jury duty work. So I'm not versed on what other states do for that part, for those portions. I just want to go back though for a minute as far as you also have to take into consideration with this case. I mean, it is a remarkable case where we will learn a lot of facts about, obviously, as the case moves on, but there, quite frankly, is some really bizarre behavior, and the religious fanaticism, the things that we already know about with Lori Daybell and Chad and their life and where they went off and where they spun off in their lives does have the ability to take off into a circus atmosphere. And I don't think not having the cameras in the courtroom means that they're not getting that it's not fair here. Lots of people are still watching this. All the press is still watching this. People are watching it. People are reporting on it. It's not like somebody's getting away with something that is suspicious or that they're trying to hide anything, because it's still getting a lot of attention. It's just not getting as much of a media presence as some people would like. But this is not happening in secret by any means. This is still a public trial, and all the rules of evidence, are there for everyone are there for the lawyers to litigate. So I really disagree that there's some sort of conspiracy or some thought process that the judge has something to hide here. This is still a very public trial.
And shout out to KCL for updating us here. Joel, it is now 30 of 42 jurors all done for the day, so they're inching closer. And Jean says she thinks we'll have a jury seated by the end of the week, and certainly looks like we are headed in that direction. A few more comments and then some bigger picture questions, and then we'll wrap this all up. Carrie G writing, Lori smiling is grotesque. Your children are dead. Have the decency to show you grieve. Followed here, and this is a great question. By the way, what happened to all the promised audio? Court website claimed it would be available at the end of each day. I have not heard the audio yet. I'll have to check in once again with Gigi McKelvey, who has the podcast Pretty Lies and Alibis. She's one of the go-to people for this case. So if you haven't, check out her podcast, as well as Lori Hellis. They were both on the show yesterday. And Lori has a blog on all this, and she's writing a book called The Lori Vallow Story. So check them out, because they are right on top of everything. We've got Texas in the house, and a hello from Nampa, Idaho, a town that I have never heard of growing up in New Jersey, but now I have. Let's step away from, kind of the minutia of jury selection and all this. And let me ask you a big picture question here, Tara. And you may or may not want to answer it, so you can tell me to buzz off if you don't. But we posed this question a while back. Is Lori Vallow Daybell pure evil or mentally ill, or maybe a little bit of both? Have you thought about this? Because if what she's accused of doing is true, it's pretty wacky. What are your thoughts?
That is a really big and very difficult question, I think, to answer. I think anytime someone intentionally takes a life, there is certainly an element of evil in them. I can't imagine taking a life. And so it's hard for me to even wrap my brain around. There certainly seems to be indicators here that Lori Vallow Daybell suffers from some pretty significant mental health issues, perhaps. And I say that based on, number one, the issue of her competency, which was came up early on in this case. Even some of the behavior that we all kind of read about, this idea of zombies taking over the kids, and this pattern of really strange behavior, not telling anyone where the children were, fleeing to Hawaii, going across state lines. It's certainly not the behavior of someone that we would consider who is undisturbed, for lack of a better term for it. So in my opinion, I think that mental health issues are certainly present here, or some indicators of mental health issues may be present here. And I have to correct myself, Joel. I think I said Marsha Shaver for the prosecution in the O.J. Simpson case, and that was actually Marsha Clark. And I was like, wait a minute, I got to go back in my memory. So before I get all sorts of feedback on that.
All good. And it stands. It is corrected on the record. Shout out to Lori Vallow. She says this chat is so professional. Really nice to see. She's in the Great White North in Canada. And I think she was having a little issue with her mother. I hope everything is okay there. Followed here by Jinx Krug. Yay, Chicago. Eastern Iowa here. So we've got a lot of the United States covered, including Southern Illinois. Same question to you, Gene. Apparently, Lori Vallow believed, according to documents, that she could teleport between Arizona and Hawaii. They believed that their kids, JJ and Tylee, had become zombies, and those zombies had to be eliminated, and that was why they had to be killed. You have a lot of experience. In some way, lawyers are like my parents. My dad was a psychiatrist. My mother is a social worker. You've got to understand the human mind. So same question. Do you think she's pure evil, mentally ill? Maybe is it possible to be a combination of both?
Yeah, that is the $1 million question, isn't it? I think it's hard to say, but I think that it's a combination of both. Certainly, her issues of mental competency were challenged, and she was hospitalized in Idaho. There is no, you can't have not guilty by reason of insanity. We don't have that defense here at all. And so, even though she is competent now, competent meaning that she is able to assist her lawyers in the day-to-day of the court proceedings, and that she understands what's happening. It doesn't mean that she still might not have some pretty crazy ideas in her head, and that she has some crazy beliefs. And that doesn't mean, that a lot of people might think that what she thinks is at all normal. But that's not the test here. She competency in this instance means that she's able to assist in her defense. Do I think that she's pure evil versus pure mental ill? I agree with Tara that there's both going on at the same time, because I do think that she knows the difference between right and wrong, or else she wouldn't at this point be able to be declared competent. That is one of the big things that they have to determine, is that she understands the difference here. And this is the behavior that people are already starting to report, that some of your viewers are seeing, that when she's on the news, that she's smiling inappropriately, that she doesn't show grief. I mean, this is a tough position for the defense, because she's constantly, people are going to be looking at her all the time. And what they see is not normal behavior. I mean, it doesn't appear to be or feel like normal behavior. And so, is there a little bit of both going on? Absolutely. And I think anybody who takes the life of somebody else has a little bit of both in them anyway. You have to have a little bit of something wrong with you, whether it's just pure anger, out of, and again, involuntary manslaughter, and you just cannot even control your anger. I'm sure there's a mental illness for that portion too, where you snap. But there's also some evilness that goes along with it, that you couldn't control your behavior. So I think it's both. But in this instance, it's super complicated, because her children were involved. There's another murder there's another person that's involved. Plus, she's got, involved in the cases in Arizona. There's a lot going on here. That's for sure.
I love Jean's no nonsense style. She breaks things down easily. David writes, I'm not going to put the comment up because I want to get to this comment on the screen, but he writes, hello from exotic New Jersey. Loving the show and the expert guests. That's my hometown right there. Highland Park, New Jersey. Super proud to be from Jersey. Some people say I'm crazy. I was just in Jersey for my dad's funeral, unfortunately, and I got my girls some shirts that say Jersey. So they are proudly wearing them. Blue Reader writes here, Gene, why did the state, and I think he touched on it, I just would like you to clarify here, why did the state jeopardize a possible death sentence with turning over the documents on the deadline?
I don't know that they knew that they were going to be jeopardizing the death penalty. The state has an obligation, absolutely, to turn over the evidence. And it's an ongoing duty, even though we have deadlines for both sides. Discovery is an ongoing duty. So even as you get more discovery or more things come to the state or to the defense, you continually have to turn it over, even if it's beyond the deadline, because we don't, as Tara said, we don't do things by surprise. In this instance, it sounded like there was quite a bit of information that they had not turned over until late. But the penalty for not turning it over would have been far worse. I don't even want to think about that because that would have been awful. So I don't know that they intended that they thought that this would result in the loss of their death penalty. They might have thought for sure that there's going to be another continuance and to give the defense a chance to go through it all. And I think that the judge, also saw this as, this is a case that has got to, that whatever they turned over, the judge must have thought they can work through what they've been turned over, but there's some penalty as a result of that. And maybe Dave was right when he said he kind of picked a middle of the road compromise. But I don't think that they didn't do it with the intention of getting rid of the death penalty. But they had to turn it over, that's for sure.
Louise Rouleau writes, she can't plead insanity in Idaho. Tara, there is no insanity defense. How would it work? She would have to be proven incompetent to stand trial by a mental health evaluation, Tara?
Well, we don't have the insanity defense in Idaho at all. And I don't think we've had it since like the 80s, early 80s. So, what could happen is what happened before, as we kind of talked about, which is if she's not, the question is whether she's competent to stand trial. And at that point in time, if she's deemed like she was last time, not competent to stand trial, she gets medical treatment. It's the Department of Health and Welfare, I believe, where she goes, and she spent about, I think, 90 days or so, and came back and was then deemed to be competent to stand trial. So no insanity defense in the state of Idaho.
P. Willie writes, and we're getting to the end here. The malevolent life of Lori Noreen Cox Yanes LaGoya Ryan Vallow Daybell. She had a lot of husbands. Finally being brought into the light of accountability by a jury of her peers. I don't know about you guys, but I'm married to one woman, and it can be tiring with 3 kids. So can't imagine 5 wives. But I like that comment. Well written there. Followed by Don's comment here. And Gene, this is for you. What are the chances of Chad testifying against her? He probably would require a deal for Chad. There is a lot of talk that he could turn state's evidence. What do you think?
I don't know. I think there's as much conversation that Lori's gonna say it was all Chad. They're both defendants here. They're co-defendants, even though they're gonna have separate trials. There's some very damning evidence against Chad. That's been well publicized about his involvement in this case and involvement with the murders of these kids and the hiding of their bodies. I think it would be very difficult for Chad to cross fingers and say, no, it was her fault. And she says, no, it's his fault. That's why there's a conspiracy here. That's why the state gets to say that they conspired with each other and that they were both involved in this. And I think it's well documented at some point. I don't know how deep they will go into this with all of the zombies and the religious aspect of it, but they're going to have to address it. Clearly, they're going to have to address it in some form or fashion in the trial. But from what I understand, that was Chad was more of the leader in that, and Lori came along into it. But that would be something if the state were to try and give Chad a deal to go against Lori, and it would have to be some really, really, really compelling information. And I just don't see that as a possibility. But stranger things have happened.
And Tara, do you think there is a chance? By the way, Tracy says, I really want to get in her head. Lori Vallow said, I think that could be a mistake. I don't know that I would want to be in there. But Tara, to you, do you think that Chad could turn on her? That's always a possibility, right?
I mean, I never say never. Certainly, he could decide that he wants to flip on her, decide that he wants to, turn state's evidence. But whether or not he would get some sort of plea deal from the state as a result of that was really the question. And as Jean mentioned, I mean, in a lot of ways, he seemed like the instigator and leader here. Certainly, that conspiracy charge indicates to the rest of us that the state believes that as well, that they were in cahoots together. But I would be surprised if he got some really good plea offer from the state to flip on Lori. Sometimes in these sort of circumstances and situations, you'll see that the plea deal is cooperate and perhaps we'll take the death penalty off the table. And that becomes the negotiation. But everything else, as far as how long of a sentence, is still on the table. So a possibility, but I join Jean in kind of the skepticism that she has. I would be surprised if the state was really pushing for that at this point. And
Susan Moore writes, I believe Lori's alibi is not being there when all three were killed, which is a motion that what they admitted that in a courtroom, but she's also charged with conspiracy of the murder 3 times. So I love this comment here. Ash Rose, love listening from San Diego while walking my dog. I can tell you it's not snowing in San Diego, and I love dogs. So 2 good things. Anyway, I already forgot what the last comment was. So, and my mind is starting to go. It's been a long couple of weeks. Tara Malik, she's an Idaho licensed attorney practicing in state and federal court in business and commercial litigation. She has experience, and a lot of it, in both civil and criminal law. She is as good as they get. We had her on for the Idaho quadruple homicides. We're going to have her back on for that and for this. But Tara, what are you looking for in the coming days? You think we'll get a jury by the end of this week? And then how long do you anticipate a trial like this lasting?
I do anticipate that we'll have a jury by the end of this week. And, this case could, I think that the estimates that I've seen have ranged anywhere from 8 to 10 weeks of trial. It certainly sounds like there's a lot of evidence. This is a complex case. It's not straightforward. There's circumstantial evidence as well. And I would anticipate we're going to be in this for quite a bit of time. And that's without surprises. And there's always 1 or 2 surprises that come up in the midst of trial, things that don't go the state's way or the defense attorney's way, and even mid-trial motions before the court or issues of evidence that may pop up at the last minute. So I would say at least 2 months, if not longer than that.
And Gene, to you, Nelly Belly Alibi. I have no idea if I'm even getting that right. It's like reading license plates on the road, trying to figure them out. Do your guests have thoughts about how cases like these are disseminated on social media? Should there be restrictions of any kind? I think the bigger question, Gene, is we live in a brave new world. You've got these jurors. Um, Everyone has phones. All the information in the world pops up on these phones. How hard is it in a modern day in 2023? Is it to keep information from a case as high profile as this out of the hands, or more importantly, the eyes of potential jurors?
That is a big question. That's why there's going to be 6 alternative jurors sitting on this case. And the jurors, as I said earlier, are going to will be reminded every time there's a break in the case, every time they walk out for lunch, every time they come back in, every time they leave at night, that they're to stay away from, any sort of social media. And they will take an oath to the judge that they will do that. Now, I don't, you have to rest a little bit on faith that they will do what they say they're going to do, and that they will really just listen to this case from what they hear in the courtroom and not from anywhere outside. It is really hard because you get your phone on, and I get automatic, updates that flash across my phone all the time. CNN reports this or KTVB reports that, that just come up all the time as notices. Now there's things that you can do to truly try to avoid that, but they will be asked every day, all the time about trial publicity. And they're just going to have to be really, really super careful about trying hard not to listen to any of it. We want these jurors, we really do want these jurors to decide this case based on the information that they hear in the courtroom, of the evidence that they hear coming from the testimony that the judge is going to allow in, and that the system works. And we don't want them making their decisions based on things that they're hearing outside the courtroom that don't have that same level of trustworthiness, and don't have the ability for the lawyers to be able to question and talk to them about it. And I think it goes back to my comments about cases like this that are so big and have had so much pretrial publicity, and that have so many issues involving so many things. I mean, the children, the mental health, the zombies, the mother-child relationship, and there's so much going on here. It's just really important that these jurors try hard to follow the judge's instructions.
And if you didn't know, you will know now that Gene Fisher recently retired after 33 years of service at the Ada County Prosecutor's Office as the Special Crimes Unit Chief. During law school, even before that, Gene spent a lot of time at the Ada County Prosecutor's Office before being hired directly out of law school in 1989. And by 1997, she became the supervisor of the Sexual Assault Unit and is focused on those cases ever since. P. Willie writes here, Alex Cox had a sick relationship with his younger sister, Lori, and was convinced he was her personal protector, punisher, and assassin. He had a prior brain injury when 16 years old with a functioning level and easy for Lori to control. Be interesting to see how much of that comes out in the trial. Some of those questions are still unanswered, but no doubt it was not the most normal and functional relationship. Gene, you get the last word here. When will this trial, do you think, start? How long do you think it lasts? And what are you looking for?
I agree with Tara. I think we'll have a jury by the end of the week, the way things are moving. The state can definitely have a few less witnesses. The defense might have a few less witnesses since it doesn't have the death penalty involved in it. So it could move along a little bit faster, but there aren't a lot of shortcuts. So I think we're still looking at about 8 weeks or so. And then, we don't have, because the death penalty is off, the jury will not have to sit for that extended period of time where they determine the death penalty or not, which is a whole nother phase of the trial. And so they will not have to sit for that part of it. And then that will be the judge's job, presumably, if there is a conviction sometime after that. So I think we're looking at about 8 weeks.
You heard it there, 8 weeks, 2 months. We'll see if that is correct. A quick programming note. We will be live tomorrow at a special time, 12:30, a lunch live. And so far we have Ashley Wilcott, Judge Wilcott from Court TV. She's going to be joining us to talk more about this case. Thursday, live at 5 p.m. Eastern. This is a screwy week. And then Friday, back to live at 12:30. I'll be tweeting it out at Podcast STS. We'll hope you will join us. And then next week, back to the regular time at 7 p.m. Eastern every day of the week except Friday. Until then, thanks so much, STS Nation. Thank you to Dave, Leroy, Tara Malik, and Gene Fisher. Love you, America. Stand by for 1 second.